But if you look like Apollo, they will never change.
Welcome back to the Mutunga succession debate. Again on Twitter, remember the hashtag is Mutunga succession. We were just getting started. And my second question, I'll start with you, Apollo. Are you satisfied? We have 6 candidates now, but are you satisfied that JSC narrowed down to the best 6?
In the circumstances of the people who actually applied, yes, I'm satisfied. Again, we did not have a big pool of to choose from, so I'm satisfied.
Anyone who's not satisfied in the panel?
I think I'm not satisfied on one point, that it's rather unusual that two Supreme Court judges made an application and one was found was shortlisted and the other one wasn't shortlisted. I think this has been a matter of public debate, and people are asking what happened, because especially when you know that one is much more senior than the other. So I think it's a debate that's going on.
Right.
I'm not satisfied.
Either you're not satisfied?
Yes, this is because of the system that we chose to put in place in choosing a Chief Justice. I think we were wrong when we put this provision in the Constitution. There are very many good people out here who can be Chief Justices of Kenya and do a wonderful job, and they're not among the 6. To that extent, I am not satisfied.
What would you have preferred when you talk about the system?
I think the system itself would have worked itself differently, so that the public lynching of the applicants when they're being interviewed, when we saw that happening last time, is not something I would wish for anybody in this country
to go through again. It was a public gesture that should never have been allowed to happen. So many people who would otherwise serve as good Chief Justices did not apply because of that system. I see you shaking your head. I don't know if you're satisfied, you'll tell me, but what he's just raised in terms of he doesn't want anybody to go through what others went. Do you think that process of public scrutiny inspires confidence in the judiciary or otherwise?
I don't think it's about the process of public scrutiny. It's very important indeed, and I'm happy we're here tonight because, look, this is the other arm of government. With respect to the executive, we know what happened. It's a rigorous process to get to be the president. With respect to the National Assembly and the Senate, we know what happens for those ones that become speakers. So I think it's absolutely important that there is public scrutiny. However, it is a manner in which the scrutiny is carried out. I can tell you I am not satisfied, and I know there's a case pending in court, but may I say I'm not satisfied because I didn't understand why some of those people were not shortlisted, considering that they seemed to meet the bar in terms of the hard skills, as I call them, the ones that are provided for in the Constitution. And that's exactly why a lot of people will not apply the next time, because they're like, you don't want to be, bumped off, just like that. You don't want to be treated, so shabbily. So that's the thing.
During the vetting process you're talking about? During the vetting process?
No, not even there. The shortlisting, for example, because, people have their own reputation. They've done what they can for this country. To not even give them an opportunity, to go in for an interview, and yet they meet that criteria, I'm not sure it's a good thing. And I'm saying this knowing that the case in court, so I want to be very careful about what I say.
The ruling will be Monday.
And, Evans was very concerned about the women not applying. And that's the reason. By the Evans, there are very many women out there who qualify, to be Chief Justice, apart from, of course, Justice Namboye. And the reason they will not is because they're scared. Actually, they've become very brave women, have become scared of what the process portends for them.
Judy is scared.
In terms of public scrutiny and the vetting process, that Gladys and Evans are saying is humiliating.
I survived it though.
Public scrutiny is quite necessary because publicity is the hallmark of fidelity in any recruitment exercise. And the office of the Chief Justice is a very big office. He's supposed to serve all of us, supposed to be the link between the judiciary and the other 2 arms of government. But most importantly, I think the absence of Professor Ojwang and retired Justice Errol Rigera in the list of those who are shortlisted raises a lot of eyebrows. And this is quite important, bearing in mind that the GSC itself had said it will take a maximum of 21 days to do the preliminaries. Now, before even the 21 days lapsed, they did this in a record speed of 1 day. Why the hurry? Many of the issues that we are now being told in the press could be the reasons as to why these individuals were not shortlisted appear not to be credible. So to that extent, I think there's a lot of disquiet. And it may appear as water under the bridge until maybe the court rules otherwise.
Yeah.
But I think for now, perhaps we should concentrate our discussion on the seats.
On the seats that we have.
Still on that topic,
Yeah.
Yeah. If you're over 65 and you're already serving the Supreme Court and you're not listed for Chief Justice, something is wrong. You should take the early rule at 65 and retire.
Yes.
Because you retire with all benefits. That is the Constitution.
I don't think so. I mean, just because a panel of men and women say that you're not suitable to apply for Chief Justice doesn't mean that you're unfit to sit as a judge. Hey, these are human system, people. And by the way, the question is, what are we learning as we go? Because we are a young democracy, so to speak. Okay, and we are learning things. And so I do not think that somebody should shy off simply because they were not shortlisted or because they do not qualify to become the Chief Justice.
I think we're saying just that we don't mislead members of the public. I think my colleagues here, all of us are clear that the public scrutiny is not something that we're saying should not be done. We're just saying that it must be done with decorum and with respect.
What was the biggest problem last time then? You keep referring to
when I watched the interviews, I mean, when you call, I think I remember one judge was told that she's like a kindergarten teacher. You know, during the interview, I've attended many interviews in my life done by, you know, the big firms, Pricewaterhouse and the likes, but they have never talked down on you. Because what they're supposed to be doing is getting information out of you that would help them make up their minds whether you're the right candidate or not. So to call people nursery school children or call them that you can't write or whatever, you don't have to say that. And also, hopefully we hope that the Judicial Service Commission during the interview shall refrain from making speeches as the interviewee and actually ask a very short question, make the person speak. The person being interviewed should speak longer as opposed to the way, which is what we saw last time. We were treated to great drama. But I think it was a good thing because it was the first time we were doing it, and I think it was a proud moment for Kenya. But we hope that now we've learned some lessons from it and hopefully not humiliate extremely senior members of the judiciary.
But okay.
Yeah, I concur. There are certain questions that should not be asked. But the scrutiny must be...
certain questions that should not be asked, or
yes.
there's certain
words that should not be used.
Okay.
But
questions should be asked.
Yes.
Derogatory language must not be used towards the candidate.
Yeah, but
I think that's what I mean.
Yeah, but the scrutiny must be so intense because who are we selecting here?
Yes.
This is the person who is going to swear in the president. This is the person who is also the head of one of the arms of government. This is the person who also lead men and women who dispense justice and ensures that access to justice is given to everybody who wants it. So the scrutiny must be intense and very, very intense.
Right.
Yes.
Okay.
Now,
okay.
I think the scrutiny has to be intense, but it doesn't need to be frivolous. During the exercise to hire the Chief Justice who just retired and the hiring of subsequent judges, we saw so many frivolous issues that were being raised, most of them unfortunately which Apollo appears to have processed. So we hope this time, Apollo, perhaps you could let those issues rest. For instance, if a particular issue has been litigated in court, it has been raised against a particular judge once and twice and it has rested, and then it emerges again. I mean, it doesn't add progression to the process of ensuring fidelity in the appointment of a public officer.
Right, let me move to another issue, a big issue, corruption in the judiciary. I'll start with you, Nelson Harvey. You've talked about it in individual capacity before and even spoke of cartels. But address yourself to corruption. How big of a challenge is it in the judiciary? And who among the six, because you didn't say who you think should be or should not be, but who among the six you think is best suited to stand or fight corruption?
Corruption in the judiciary is a very big prehistoric monster. It's like a big crocodile. And the main reason as to why we've had corruption in the last 5 years is because the Chief Justice was just retired, did not have the capacity to lead and provide guidance. And as a result of that, there was a big lacuna which prompted individuals to take over control of the Judicial Service Commission and ultimately the judiciary. And it's very easy to see the footprints of some of these individuals amongst the 6 candidates. Let's look at the public accounts report.
Okay. These individuals, for the sake of the viewers,
yes,
these are the cartels you talk about.
Yes, these are the cartels. Look at the public.
So it's important for the public to understand what cartels really do,
yes,
the judiciary.
Yeah. And for the public, the cartels tend to hide within the established systems, but they're not legitimate individuals entitled to have control over system. Now, if you look at the report by Parliament on the audit of the judiciary, about 1.05 billion Kenya shillings appear to have been lost between the year 2010 and 2012. There's been so much hype in the media attributing that loss to one individual. But in actual fact, blame has to stop with the leader of this institution and all those individuals with whom he presided over this problem. Now, Parliament has recommended investigations by the DPP and the Ethics and Anti-Corruption Commission against one candidate who is a Supreme Court judge and who has applied to be the Chief Justice. This candidate has had a very checkered history in the institution to deal with corruption. He was in the defunct Kenya Anti-Corruption Commission with very disastrous performance there. And then when he came to the Judicial Service Commission, he presided over 3 very important committees: Human Resource, Finance and Administration. And it's within this time that the problems that bedevil the judiciary right now were created. So to that extent, I will recommend highly against the recruitment of an individual with such a record. Yes.
Okay. Let me get Nelson Harris' response on that.
It's easy for Nelson to talk about corruption amongst judges, which we know about, and we are trying to root out. But it's quite another to avoid to say that this corruption is taken to the judges by lawyers, by litigants. So the discipline must also start from within us. It's not enough just to point a finger at the judiciary. It's enough for us to tell ourselves, let us keep the judiciary clean, let us keep our courts clean. You know, corruption is like doping. So you get an unfair advantage if you're going to bribe a judge against me.
But Evans, you need to appreciate who are these lawyers you're talking about. In actual fact, the lawyers who we qualify as the cartel were the lawyers that had control of the retired Chief Justice. They controlled the Judicial Service Commission.
You don't think Mutunga Senior, you don't think he was in control?
No, he wasn't in control.
No, first of all, Mutunga was the first captive of the cartel in the judiciary. His own record that he had a cartel around him that made decisions for him. And that's why when we're looking for the Chief Justice, let's get someone who is a man or woman of great wisdom, and a man or woman who has self-confidence and is self-assured and is not dependent on people who are quarter his age to make decisions for him. So I think that's very important. And I would like to see a situation where the new Chief Justice has to be someone who can defer issues to their own colleagues. Because within the judiciary, there are many great men and women who actually understand the system. And therefore, if I was a new Chief Justice, I would definitely go to people who've served for very long in the judiciary and said, how does this work? How should we do this? And that is why when we look at the character of the person that we are going to appoint as Chief Justice, it has to be somebody who can seek advice from their own colleagues.
Okay.
I don't know, can I just say something? It is true, there is corruption and there is perception of corruption. Luckily, I practice in the family division where there is less perception and I think less corruption. Having said that, I don't think there is any excuse at all for a judge to be corrupt. It doesn't matter the cartels out there. It doesn't matter that the money is placed at his doorstep. The standard we expect of a judge who sits to hear cases must be such that that temptation of the good outside his door, notwithstanding, he will not take it. So for me, it doesn't matter that it's lawyers that take the money there. And I'm not excusing my learned colleagues at all. I think we must be able to put the judges on a pedestal and tell them, you cannot be saying that you're tempted by the lawyers. Having said that, and Gladys, to respond to you, I don't know that there's any judge who will ever work alone. The responsibility placed on the head of the Chief Justice, or any judge for that matter, is such that he must consult. Because, I mean, no one is born a Chief Justice. These are skills, I think some of them, that you learn as you go along. You'll be confronted with, sorts of situations, like the people who are waiting outside the court because they want a determination on who their next president is going to be, etc. How is it possible for one human being to even bear that responsibility to act alone?
Okay.
Yes.
So my question, as you respond, and maybe even Sasi, you're eager to respond, who do you think among the six is not or cannot be a captive of such cartels? Gladys, it's important to point out here that there's a case against you, and we're not going into the merits or demerits.
No, I have a case against them.
And you have a case against them. We're not going into the merits of your case against them or the case against you.
Yes.
Right, I'll follow you.
Let's start with the people who are possible captives. Possible captives have actually brought themselves out. As I said, in the ongoing colloquia of judges, one of them has stated clearly that if there is any case in which the government has any interest, the judge has invited the Attorney General to dialogue with the judiciary. That's a sure candidate of captive of those cartels, if that.
And you still won't mention that?
Well, it is known. The judge who said this is Justice Nambuye. It's been reported.
In fact,
yes.
Who said, a judge who says that is actually the one who should be Chief Justice. Why? why do I say that? Our Constitution now allows for dialogue. It allows for external dispute resolution, mediation, so that when we have a new
That's
problem,
interpreting the Constitution a little too literally.
don't call the parties involved, by saying they are calling the Attorney General or anybody, the other parties will be involved in the mediation.
Right.
We must find a new way of resolving issues that affect our country.
Okay.
We have a new constitution that has got several problems. And the way to do it is by dialoguing.
May I say something, because this is my senior?
Yes.
Yeah, I mean, I think, yes, I think I would be interpreting the Constitution a little too literally, that's one. But two, also, why is it that, because the government is a litigant in that case, isn't it? Like any other litigant. So if you're going to dialogue with the government as a litigant, are you going to dialogue with all the other litigants too? It has to be fair. I think it has to be fair.
All right, before we take a break now, I want to engage the audience. There's something that has been said about the tenure of Justice William Mutunga, that he was a captive of this cartel. She agreed, you said it. I don't know if the three of you agreed with that.
Our senior here took my words as I was still talking.
Okay.
He jumped into this issue of this.
But Apollo should tell us whether he was part of the cartels too.
Well, Apollo was a very senior member of the cartel.
Thank you. Hussein, I don't know. I think maybe being the chief executive of the Law Society makes you to be part of the cartel. If that's the case, then that's because I was the chief executive of the Law Society, and I had a lot of issues to talk about in the judiciary.
Okay.
But what I can say is this: if the next chief justice is coming to a bench in which 3 of the judges they are sitting right now in the Supreme Court have been pronounced as having misconducted themselves, that's what the chief justice is going to find. And it's also no secret that Justice Ibrahim, Justice Ojwang, Justice Jokindungu, their own employer, that is the JSC, has given me a letter agreeing with me that indeed these people have misconducted themselves. Now, the situation that we are going to find is this: they say that, but they do not go further by then saying, okay, if they have misconducted themselves, why should they be on the bench? Why can't they just go the whole hog, look at the Constitutional Article 165, and then recommend the formation of a tribunal, then to try and see if indeed what they are saying is true.
Okay.
But that is the situation that we are going. But the question of cartels, people have talked about cartels. I was for a very long time I had to take a break from going to court as the chief executive, and I was not in the corridors litigating.
Okay.
I think I need to clarify something about Apollo has said.
Evans needs to respond to this, because you're talking about whether he was a captive of these cartels. William Mutunga.
Gladys worked within the judiciary, and she was the first chief registrar. She will best know who the cartels were. We looked at the judiciary from the external, and I think that just like the president, who is the head of the executive, the Chief Justice, who heads the judiciary, requires a team of advisors.
Yeah.
That is not to say that he's being held captive. It is the advice that he gets that we can question. Yeah.
Okay. Team of advisors, not a war council.
And I think this team of advisors cannot be outside the Judicial Service Commission. When a Chief Justice has a team of advisors, being his friends from many years before, who are practitioners in the court in which he's supposed to administer, there is a very big problem. It is
any of these judges will have relationships with lawyers and with other people who necessarily are not in the Judicial Service Commission. That will definitely happen. And they'll obviously have discussions whether on cases or whatever that is happening in the judiciary.
No, but he doesn't have a handicap. He has the Judicial Service Commission within which to seek advice from.
Okay, Judy, very fast.
No. I think you don't stop being a human being, just because you sit, as a Chief Justice. And I think it's very possible and very right to broadly consult on some of the issues. And unless you're being told, these people are giving you money or bringing you the money from out there, I don't see what's wrong with it. Because, you see, the person has the presence to be able to tell what is right and what is not. But I think in some of the decisions you make, you need to take the responsibility of having consulted somebody else. And the person may well be within, but the person may well be without.
I think in every country where there has been a requirement for consultation in decisions regarding the judiciary, it's consultation within a set structure. The judiciary does have a presiding judge of the High Court, who's like the president of the High Court. Right. There is a president of the Court of Appeal. Yeah, and there is a person elected by the also a head of stations within the magistracy. So even if you're consulting, consult your friends, you can, but you must also consult within the set institutional structure.
Right, we're taking a break right now, commercial break. Keep talking on Twitter. The hashtag is Mutunga Succession. We're coming back with your feedback and questions and the audience questions. We're back after this short break.